Are you Ana Gonzalez?
Yes.
Welcome.
Guzman now, Judge.
Ms. Guzman. Court marks you present in person. The person to your left is your lawyer, Ms. Soto. Mrs. Cotto, go ahead.
Judge Madeline Escoto for Ms. Guzman. Judge, I have been able, thankfully, to confer with Ms. Soto. Judge, always a pleasure to work with her. We have agreed to, with the court's permission, to have a guardian ad litem appointed to the minor child. We have agreed to Leticia Garcia, Judge. And I had filed an order and a motion to that effect. We're asking that the court sign the same. We have conferred with Ms. Garcia today, and she will accept the appointment. And she is quite qualified, Judge, based on the circumstances of this particular child, to be able to come up with some recommendations for the court.
Excuse me, Ms. Soto.
On that point, no, Your Honor, Ms. Garcia is agreed qualified to handle this matter. And we did agree to her being appointed as guardian ad litem as necessary in this case.
The only other, I guess, decision regarding that matter that the court needs to make, let's see if there's an agreement, the payment of Ms. Garcia's fees.
We've agreed to 50-50.
Court has signed the order appointing Ms. Leticia Garcia as the guardian ad litem, tendering the original document to the coordinator.
The next matter is, Judge, we've agreed on a social study investigator pursuant to my motion.
Judge, that one I did want to confer with my client on that one, to that proposal. And we did exchange some names for that social study, but I do want to make sure that my client understands what it entails and that he's in agreement to that, because I have not discussed that point with him.
And that's fine, Judge. We can take that up at the next hearing, given that we have Ms. Garcia now on board and she's going to provide us recommendations for Dad's access to Bobby.
Court will, by agreement, abate hearing the request for the appointment of a child custody evaluator. Ms. Flores, give us 2 dates. Oh, one question. Ms. Soto, Ms. Soto, how many children before the court?
One child, Judge, it's a male, and he's 15 years old. And the second thing that we've agreed to, Judge, in conferring is that we're going to file an agreed order for you to interview Bobby. And we just ask that the court provide us your next available date. This case has some sensitivity, Judge. Therefore, time is of the essence. Bobby has an appointment tomorrow at 7:30 at Border Region. Ms. Soto has been notified.
All right, guys, let's break this down, because this hearing immediately turns tense the second both sides start negotiating around a troubled teenager caught in the middle. Lawyers are agreeing on guardians, evaluations, and emergency mental health assessments, while the father's side makes it crystal clear he feels locked out by the restraining order. Everybody's speaking politely, but underneath it all, this is a full custody war already forming.
No parent shall interfere with Border Region's recommendation, whether they will say inpatient or outpatient. That remains to be seen.
And Judge, so that was discussed with me. My client also had him assessed previously at another facility. And that's one of the things that's, I guess, kind of in dispute and controversy between the parents. The restraining order restricts my client completely. He's had joint management conservatorship. So that is something I need to confer with my client, because he has not had access to his child since the judge signed his restraining order. Because of the sensitive issues that have come up, he does not want to be denied access to the child. He understands that there's a need for an ad litem. I've advised him of that as well. But he doesn't want to have the court have a say in as to who is going to assess his child.
And so, Judge, just a little background, and the court, I'm assuming, I know, read the affidavit that was attached. And so Without getting too much into the facts, Bobby was self-harming. This was reported by the school. In fact, there is a subpoena. There's a Marla Alanis that I've subpoenaed today. She's a school counselor. I have her on standby because I knew that Ms. Soto was just hired and that we probably would need more time. What we've agreed, Judge, I thought, was that Ms. Garcia, after Bobby is assessed tomorrow by Board of Region, that Ms. Garcia would see all parties tomorrow, including Bobby, and that she'd come up with some recommendations for interim visitation between Bobby and his father. Ms. Guzman is not here to hinder his relationship with his son. But things have happened that are concerning, and I don't want to go into those facts, Judge. I think that for the time being, I thought that we were in agreement. Bobby would be assessed tomorrow by Board of Region at 7:30 in the morning. That they would see Ms. Garcia tomorrow, all parties, and that she would come up with some recommendations in the interim so that Mr. Castro would be able to see Bobby.
And just in brief response to that, and in consideration that this is being live streamed, I don't want to put the child's sensitive issues on air, but there's items that my client feels were not included in the affidavit. He's also concerned for his child. So we wait for Ms. Garcia to give a recommendation after interviewing the parties, interviewing the child, being assessed by Board of Region, which is not the facility that he would have liked, that he has been communicating with. He does not want to be deprived of being there for his child and supporting his child with this difficult time. And right now he's being denied that through the restraining order. So if the court's in considering waiting for Ms. Garcia's recommendation, my client would ask for an expedited hearing if he's not in agreement because he does not want to be denied any access or a say in his child's care.
And the problem was, Judge, my client took the child to Board of Region last week and he interfered. And the appointment was.
Now the real conflict surfaces. The mother's attorney claims the father interfered with a prior mental health appointment, while the father argues he simply doesn't trust the chosen facility and refuses to lose his voice in his son's care. The judge quickly realizes this case is balancing on emotional landmines. Both parents claim they're protecting the child, but their distrust of each other is becoming the loudest thing in the courtroom.
Was canceled before Bobby was assessed, even though he was self-harming, and that was reported to Dad. And the next available appointment that they could give him was on the 6th, and that's tomorrow.
Mm-hmm. So let me give you 3 dates based on all of these things. I was looking at the calendar and I was really tempted just to give you the next one in June. Ostensibly, this child is in school and that's school period, whether it's LISD, USG, or some other educational institution, should be out by the end of May. So let's do this. I'm going to schedule this TRO and temporary orders for May the 19th at 2 p.m. Now, I asked, pretty sure I asked Ms. Flores and Ms. Rodriguez to give me other options, because I think that one might be rescheduled to the morning or have a later start time. In any event, that gives the parties some time to talk to Ms. Garcia to get the evaluation. If you agree with Ms. Garcia, then that eliminates the necessity for the hearing. If not, you'll have a hearing. And then, Ms. Flores, give us 2 dates. A final pretrial hearing in 30 days and a final hearing 30 days after that, give or take.
In 30 days, that'll be June 4th at 2 p.m.
No, 30 days from May 19th. give or take 1 or 2 weeks. It's fine.
Your Honor, the last day in June would be June the 18th
All right.
at
Yeah.
9 a.m.
At 9 a.m. And then give us a final hearing about 4 weeks after that, give or take.
July 28th.
Because we have Dr. Galvan in the midst of all of this, that may be too soon
Yeah. For the final.
for the final.
Any objection?
No, Your Honor.
Well, but we definitely want to do it before the start of school. So give us early to mid-August, please.
August 11th at 2 p.m.
And so the request for the social study will be heard then on May 19th at 2 p.m. Unless by agreement,
Right.
Ms. Soto confers. Okay.
Right. I'm going to schedule something in right now before I lose track, just in case there has been a request. I've calendared on my calendar, on the court's calendar, an interview with this child August the 11th at 1. Obviously, you can make other requests between now and then. It's already been made, but there's a chance that it may not be needed. There's a chance it may be needed that day. There's a chance it may be needed before, but at least I've blocked it off on my time. Ms. Garcia, anything that you would like to add?
Nothing, Judge. Just one thing. I've got no problem talking to everybody tomorrow. However, I don't think Board of Regent would have any type of a written recommendation.
This section feels like the judge trying to slow down 2 speeding trains before they collide. Court dates start stacking up, child interviews are scheduled, and the guardian ad litem carefully avoids overpromising anything before the assessment happens. Meanwhile, the father keeps pushing for immediate access. Terrified he'll be sidelined. The judge stays calm, but you can tell he's managing panic, distrust, and urgency all at once.
Or suggestions for that matter, if they are going to speak with the child at 7:30 in the morning. But I just wanted to put that on the record.
We'll provide, Judge, anything that she gets in writing. Ms. Guzman gets in writing immediately to Ms. Garcia so that she can, and to Ms. Soto and Mr. Castro, so that everybody's aware of what their recommendations are.
Well, that's concerning to my client and I, Judge, because conceivably, what if there's nothing from Board of Regent? Is Ms. Garcia going to feel comfortable not recommending any type of access to the child? Because, and without putting all of the things we want to put on the record, my client does not want to not have any access to his child. He admittedly is going through a very difficult time. And he's here and we're here in person because he wanted to have the court at least give him the hope that he's going to have access to his child promptly. And I just don't want to have him wait until May 19th without any type of access to his child.
Factually, the good thing about your case, Ms. Guzman and Mr. Castro, and I don't know who you are, I don't know your son. Obviously, you are spending time, energy, and resources to be here. So at least that indicates to the court that you very much love and care for your son. But the interesting thing, right? I don't want to say the good thing, but procedurally or factually, is that no matter the outcome, because of the timing of the situation, the court has this summer to play with those dates, for lack of a better term. So if more time is needed, less time is needed, summer's a good time. It'd be harder if this were happening smack in the middle of the school year, because it's summer. That gives the lawyers, the court, and you all and your son's schedule a little bit more flexibility. All right, so please, Ms. Guzman and Mr. Castro, make yourselves available to Ms. Garcia. She's been doing this a very long time. She's made very good recommendations, and she understands a lot of these situations. So make yourselves available, make your son available. and hear her out, her recommendation, and then your lawyers will be able to give you some thoughts, guidance, and legal advice after hearing her recommendation. Ms. Guzman, do you have any questions for the court? Mr. Castro, do you have any questions?
Just that I would like to see him. I am worried about his mental health. He was already assessed and recommended for a higher level of care, which was advised to mom right after it happened. It's already been almost a week since he hasn't been receiving that. And I'm just worried that something might happen.
The good thing, Mr. Castro, and I don't know the facts, circumstances, or the situations involving this case, but the good thing that I've heard from both lawyers is that there will be an assessment, so there's at least that safety net. Plus, Ms. Garcia was an able and capable legal practitioner in this area of law, family law. They're going to be able to provide a lot of resources that are otherwise unavailable to your son. So there's a lot of safety nets in place already. This gives the court at least some comfort. I hope it does you too.
Honestly, it doesn't, because I don't have the utmost confidence in Border Region. I deal with them almost on a weekly basis, and they are very inconsistent, which is why I went with Base Point Academy for the assessment.
Well, let me ask you to do this, Mr. Castro. Wait to hear the results before you judge it. Because if you go into a situation, and I suggest you don't say anything else.
Okay.
Because if I know already that you're biased against a result that hasn't yet happened, just don't say anything else. Don't put yourself in that situation. Talk to your lawyer. Anything else on this?
The ending becomes less about legal procedure and more about damage control. The father openly questions a mental health provider, and the judge immediately shuts that down before it spirals into bias accusations. Then comes a warning both parents probably needed most.
This case, Ms. Soto?
So I guess we're extending the TRO subject to Ms. Garcia making recommendations for dad's visits.
Right.
And Judge, I want to make sure that I put something on the record and just clarification purposes. So once the recommendation from Ms. Garcia occurs and my client does agree with it and Ms. Guzman does not, can that recommendation already take effect? Instead of having to wait till May 19th, or if somebody doesn't agree, he's got to wait until May 19th to see the child?
Well, the legal answer, the only way to undo a court order is with another court order. So, I mean, even if the court felt differently, I can't change that. If the recommendation is different, certainly feel free to file an emergency request or an expedited request. But remember, even if that were true, and this is why I prefaced my comments, even if that were true, and Ms. Garcia says, and Border Region says, TRO should not have happened, factually there's something else going on, we have a different evaluation. So I'm saying summer is the best time for this to happen, because if that factually isn't correct, then you can talk about makeup days. I mean, I'm just saying that that's one of many possible outcomes, which is good about the situation. In other words, your son, the outcome in your son's case will be in his best interest.
And Judge, I have one more item. Part of the restraining order states that my client cannot discuss the case, cannot disparage the other parent. He has no problems doing that. He's been complying with that and that had not been an issue. But we're asking that be a mutual injunction.
Absolutely.
So
Absolutely,
Ms. Guzman
Judge.
cannot speak to the child about the case or anything of the court proceedings. Ask him what discussions he's had with Ms. Garcia. My client will do the same, and not to disparage each other.
Absolutely, Judge. That's part of the Webb County standing orders. And
So I
for the
tell you
local
what,
rules.
since it's by agreement, why don't you submit that agreement in writing on or before this Friday at noon? Let me just add the word mutual, and there it is.
Yeah, I'll send it to her this afternoon, Judge, as soon as I get back.
And just to follow up on that point, Mr. Castro and Ms. Guzman, I'm sure if I ask, Ms. Garcia is going to say the exact same thing, but it's very easy for the court to interview a child and see if any person has had any sort of influence. So just don't put yourself in that situation, because Ms. Garcia is going to pick on it right away. I can do the same thing, and it's just not going to bode well. So just don't talk to your son about this situation. Ms. Guzman, do you have any questions for the court?
I don't.
Mr. Castro, do you have any questions? Ms. Garcia, anything else on this case?
Nothing, Your Honor.
Mr. Gonzalez, anything to add?
Nothing, Your Honor. Thank you.
Ms. Soto?
No, Your Honor.
Ms. Escoto?
Nothing, Judge. I'll prepare the order and send it to Ms. Soto this afternoon.
Ms. Guzman, Mr. Castro, I wish you both very well. More importantly, I wish your son all the best, particularly tomorrow in his interview. Good luck.
Thank you, Judge.
Stop influencing the child. Family courts notice manipulation fast, and this judge makes it painfully clear he's watching for it. The courtroom exits politely, but nobody leaves comfortable. Make sure to like the video, subscribe to the channel, and we'll see you in the next one.